we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to this live breaking episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime to break down the biggest criminal cases going on in America. And talking about a big one, the Menendez brothers. This goes back to 1989, shooting and killing their parents. And the brothers have been behind bars for 35 years. And in recent weeks and months, the family of both Lyle and Erik have been speaking out quite loudly about wanting the brothers to see the light of day again. And there's new evidence in the case, and we are joined by the Professor Emerita at the University of Nebraska School of Law, Joe Potuto. This potentially could be kind of a huge development. We are waiting for the new Los Angeles District Attorney Nathan Hochman to speak, and he took over for former DA George Gascon. And George Gascon was really pushing hard for a resentencing. Nathan Hochman is kind of a new breed, a new political figure in the city of Los Angeles. He's I think, more kind of cut and dry, very straightforward. And he said he needed time to evaluate this case. Joe Potuto, I was speaking to Josh Ritter, who is former prosecutor of the year in LA. He's actually going to be doing some analysis for the local ABC station. But he was telling me, look, this is really a prosecutor's motion. If George Gascon didn't step in, there wouldn't be talk about a resentencing. So the buck now really stops with Nathan Hochman. So what do you think this is about?
What he would
here we go.
This conference live at 1 p.m. here on ABC7 and on the ABC7 app. Erik and Lyle Menendez are serving life sentences for the 1989 murder of their parents. They claim they were sexually abused by their father. Meanwhile, the brothers are also talking about life behind bars in a new podcast interview and how a television series shed new light on their case. We'll have all of that coming up at 11:30.
And we have more breaking news. California.
All right, so that is a live look at KC on the left coast, out on the west coast, home of Space Coast. A lot of coasts there, but we are supposed to get this press conference live, and we're going to bring it to you. But Joe Potuto, what could this be about? Is it either it's not happening, it is happening, or I need more time? I assume it's one.
Yeah, I guess it could be any of the three. I mean, I'm not real savvy with when you decide to have a press conference, but I've seen a number of press conferences scheduled by public officials, which once the conference starts, you ask, why are we having this press conference? So it may be a status update. It may be a decision either that they're going to do something or they're doing nothing. I don't know that I've seen anything that.
An update on the Menendez brothers.
Sorry.
Case. Erik and Lyle were convicted of first-degree murder and
I think they're about to go
without parole. Let's listen in.
We'll be giving you an update on the case of People versus Lyle and Erik Menendez. With me up here, we have Assistant Head Deputy Habib Belian. We have Assistant District Attorney Maria Ramirez. We have Deputy District Attorneys Ethan Milius and Seth Carmack. As promised, after I became District Attorney on December 3rd, we have put in the hard work to understand the Menendez case. We've reviewed over 50,000 trial transcript pages from 2 months-long trials that the Menendezes had back in the early 1990s. We also have spoken to defense attorneys. We've spoken to the prosecutors. We've spoken to law enforcement. We've even spoken to every Menendez family member who wanted to speak with us. So we've done the hard work to understand the Menendez case. And right now, the Menendez case is on 3 parallel tracks. The first track is a habeas track. That is a motion that was filed in May of 2023, where in that motion, the Menendezes are saying that they have effectively new evidence. And we'll get into this in more detail in a moment. New evidence that militates and warrants and justifies a new trial. The second track is a petition for clemency that the Menendezes have taken directly to Governor Newsom. Governor Newsom has the constitutional power, and it's unilateral, to grant that petition of clemency and commute Menendez's case and release them immediately. He has that power today. He's had that power since 2019. He can exercise it. However, he has no deadline. There's no court hearing, and there's no appeal from his exercise of that power. And the third track is a track called resentencing. Resentencing is a somewhat California notion. There's not too many states that have a resentencing statute. The resentencing gets triggered by a district attorney's motion, or in some circumstances, the motion of a court. And that motion, unlike a habeas motion, where a habeas motion will focus on the trial itself, a resentencing motion focuses on that trial but goes beyond that and deals with rehabilitation and other factors. Today, we're going to focus in 2 different things. The first is, in order to explain the procedures that the Menendez case has gone through, we have created a video that can be accessed at our website, which is da.lacounty.gov.
Only in LA.
And that's da.lacounty.gov. And that video actually does an anatomy of the Menendez case. And it takes the case from the murders itself back on August 20th of 1989 through the investigation into the charges that were filed in the arrests. Then it looks at the motions that were filed by the Menendezes prior to the trials. Then it looks at the first trial, which resulted in hung juries. Then the second trial, which resulted in convictions for first-degree murder of both Jose Menendez, the father, and a separate first-degree murder conviction for Kitty Menendez, the mother, as well as a conviction for conspiracy to commit murder and certain special circumstances allegations of lying in wait and multiple murders. That video then continues on, though. It goes through the penalty phase, where the Menendezes were either facing the death penalty or life without the possibility of parole as determined by a jury. Then the sentencing. Then it actually goes through the various appeals, the direct appeals, all the way up to the California Supreme Court. The first habeas petition, again, with the California Supreme Court. The federal habeas petitions with a U.S. District Court and a Ninth Circuit Court of Appeals. In all those situations, as you will hear, the Menendezes have raised many of the same exact arguments that they raised in the current habeas petition. Those arguments have been heard by a variety of courts, from the trial judge to the direct appeal Court of Appeals in California Supreme Court, to the California Supreme Court again, to the federal courts. They've considered these arguments, and they have been routinely and repeatedly rejected. So we have the video that is coming out and go through this procedural history so that people can actually learn from the Menendez case and help and actually educate themselves on the criminal justice system. What I've said very often is, if the Menendez case is the portal by which people come into the criminal justice system and show an interest in it to find out what's happening, then hopefully they will educate them further about what happened not just in the Menendez case, but criminal cases that are occurring throughout this entire county, this state, and this country every single day. So the video is coming out today, and it'll be out on our website. The second thing that we have done today is that we have filed an informal response in connection with the habeas motion. As I mentioned before, there are these 3 parallel tracks: the habeas, the clemency, the resentencing. Again, the clemency is up to the governor. Resentencing we will be dealing with in the future, in the next coming weeks, with our response. But today we have filed the informal response on the habeas petition. Now, something you need to know about a habeas petition: it's not the direct appeal. The Menendezes have already had their direct appeal through the California Court of Appeals and California Supreme Court, and they have lost. They've even had one level of California habeas, which they lost, and one level of federal habeas, which they've also lost. So now they've come back for a second California habeas petition. And in coming back for that, they have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Now, in a habeas petition, there are very rigorous requirements to actually get that new trial, which makes sense because you've already gone through all these different layers of review. And if you've been rejected time and time again, at some point the system says that unless you have something very new and very compelling that is more likely to change the outcome of this case, then we are going to again reject your habeas petition. So when they come out in this case, they come out with two new pieces of evidence. One piece being an undated photocopy of a letter purportedly sent by Erik Menendez to his cousin Andy Kano at approximately December 1988, although there's no date on the letter, in which it discusses sexual abuse that was being experienced by Erik, perpetrated against him by his father at that time. That's the one piece of evidence that they've come forward, but they also came forward with a second piece of allegedly new evidence. The second piece of new evidence was a declaration by Roy Rossello, who basically said that in the early 1980s, he had been sexually abused by Jose Menendez. But the standard to actually have a successful habeas petition requires that you meet all of the following requirements. You have to show that it's new evidence. You have to show that it's timely, that it was evidence that could not be discovered at the time of the trial, but only could be discovered after the trial. You have to show that you did not engage in any substantial delay between the time you learned about the evidence and the time you brought your motion. The evidence has to be admissible, and the evidence has to be credible. Now, the overall argument about this new evidence, again, new evidence effectively dealing with sexual abuse that Erik Menendez experienced by his father, or a gentleman named Roy Rossello experienced by Jose Menendez, the defense has now argued the following. They've said to resolve this case, jurors had to decide a single critical question. Was Jose Menendez molesting his sons? The problem with saying that that is the critical question in the Menendez trial is that it's wrong. The jury never, in any of the two juries, had to resolve the question of whether the Menendez brothers were sexually molested. In fact, the counsel, Leslie Abrahamson, 30 years before, during these trials, properly framed where sexual abuse comes into play. What she said back then is that we have never said that because you're abused, you're justified in killing your abuser. We didn't argue that, and we never will. Well, 30 years later, apparently, the Menendez counsel is arguing just that. Because what the jury had to figure out is on the night of August 20th, 1989, did the Menendezes conspire to kill both their father and their mother that night? Did they in fact kill them? And what was their state of mind at that time on the night of August 20th, 1989? Did they engage in these killings willfully, deliberately, and with premeditation, or was it an act of self-defense? They had an actual fear of imminent harm, that both their father and their mother was going to kill them, and they acted in self-defense. The sexual abuse part, as Leslie Abrahamson recognized correctly back then, was not a fourth question for the jury to answer. So when we look now at the factors dealing with this new evidence, we can go through these factors. Timely evidence that is discovered after the trial, for which there is no substantial delay in presenting it. Well, if this letter, supposedly dated December 1988, written by Erik Menendez to Andy Kano, is to be believed, and that it was actually sent at that time, here's what we know. We know that Erik Menendez, during his second trial, testified for 7 days about graphic descriptions of the sexual abuse that he had encountered by his father between the ages of 6 and 18. He also talked about sexual abuse that his brother Lyle had experienced by his father between the ages of 6 and 8. That evidence was brought in, and he was asked about who he spoke to about this sexual abuse during that time period. He said he had spoken to Andy Kano. When did he speak to Andy Kano? He said when he was between the ages of 12 and 13, and Andy Kano was approximately 10 years old. That was before Erik Menendez moved from New Jersey to California, roughly 6 years before these 1989 killings. So Andy Kano also testified in the trial, and Andy Kano relayed the same information, that he had had this conversation with Erik Menendez 6 years before the 1989 killings when he was 10 and Erik Menendez was either 12 or 13. They spoke several times that year, and that was the only conversations they had about the sexual abuse, only communications they had. So now we have a letter filed in May of 2023 that is supposedly a 1988 letter written from Erik Menendez to Andy Kano about this sexual abuse. Never discussed in any of the two trials.
This sounds like a long no.
Or Andy Kano.
I said that. I put that letter in the
And we
notes.
believe it's inconceivable, as we've argued in our papers, and defies common sense, that if they had evidence that would show that sexual abuse had been communicated not just 6 years before the events, but 9 months before the 1989 killings, that it would absolutely have come out during one or both of their testimonies. So the fact that it didn't come out, again, goes to whether or not this evidence first was discovered after the trial. If Erik Menendez wrote this letter, he had it or knew about it, or Andy Kano had it and certainly knew about it by the time of the 1993 trials. In fact, it's a 1988 letter. They would certainly have it by the time of the 1995 trials. So to say that this letter was not discovered after the trial, as it's been alleged in the defense papers, we believe is just wrong. The second thing with this letter is that if the letter was real, then the question is, when is the substantial delay triggered in actually filing this motion? So what you find in the motion is Erik Menendez is saying, I didn't know about the letter until effectively a 2015 special by Barbara Walters, where this letter had been given to her, and she actually broadcast this letter in 2015. But remember, this motion, this habeas motion, this second habeas motion, was not brought in 2015. It wasn't brought in 2020. It was brought in 2023. So one of the additional standards for a habeas motion is that you do not engage in substantial delay in bringing this motion. Andy Kano had long since passed. He passed in 2003. So he was now around to actually cross-examine and see if this letter was an actual letter that he had received or not. Or perhaps he received it, but he didn't receive it in 1988. He received it at some date much later than that. So this particular letter it could have been discovered prior or during the trials, and then wasn't presented it was presented after substantial delay, even when both Lyle and Erik Menendez say that they had this letter. The third standard is admissibility. Let me deal with the Roy Rossello letter to give you an idea how the admissibility standard works. The letter has to be, it has to comply with the admissibility standards of evidence in a court. Now remember, in 1989, August 20th, the issue is what is going on in Erik and Lyle's head at the time they shotgunned their parents 12 times to their death. Are they again have an actual fear of imminent harm and death, that their parents were going to kill them that night? Or was it a willful, premeditated, and deliberate act on their part? What they have said about the Roy Rossello allegations, that he was sexually abused by Jose Menendez in the early 1980s, is they didn't know about this in 1989. They didn't know about this in 1999 or 2009. They first found out about this in 2022, or approximately 2022, about over 30 years later after the killings. So the evidence, if in fact this is true of what Roy Rosello is saying, would not be admissible to show their state of mind in 1989 because they didn't know about it in 1989. So again, it would fail the admissibility standard, as we've argued in our habeas informal response. The last standard, of course, is credibility. Is this credible evidence? We argue in many different ways it is not credible evidence. The first way, as I've discussed before, is that if they had this evidence, if this letter truly existed, the defense counsel would have absolutely used it at the trial, because it would have helped corroborate both Erik Menendez's testimony about sexual abuse and Andy Cano's testimony about sexual abuse, because that letter was 8 months, roughly 8 or 9 months before the murders, not 6 years before the murders. But it was never mentioned, its contents were never mentioned, it was never produced or in any way used during either one of the two trials. But the notion that this letter could be part of a continuum of lies and deceit and fabricating stories required us to go back into the history of the Menendez case to analyze whether or not that would be true. And when we analyzed that, what we found out is that Erik and Lyle Menendez had told 5 different versions of the events of what had happened. The first version that they told is that they did not kill their parents. This was the version they told when they were first confronted, or they first made their 911 call. And they said that someone had murdered their parents, obviously not them. When they confronted the police, and the police showed up that night, they ran out screaming and crying that their parents had been murdered. They'd come home and found them that way. They didn't admit it themselves. That they went ahead, and in that version, again, they said it was a mafia hit. And they had the police investigate whether or not Jose Menendez had been killed by the mafia. That was the first version. The second version was that their father was a violent sexual predator who raped Lyle's girlfriend. This was a version that was shown when Lyle's girlfriend came forward and said that Lyle had confronted her and said that he wanted her to testify that his dad had violently raped her and that he wanted her to testify to that at trial. She refused to do so. The third version that Lyle told was that their father had molested Erik, but the mother had molested Lyle, without any mention of Lyle being molested by his father. Again, that version ultimately didn't show up at trial in their defense. The fourth version is that Erik and Lyle were both molested by their father. And the fifth version is that both their father and their mother were going to kill them the night of August 20th, 1989, which is why they shot them first. And I want to focus on the difference in many respects between the fourth and the fifth versions. Because again, the key for the trial is basically what happened that night. What was in their head that night? Sexual abuse is abhorrent, and we will prosecute sexual abuse in any form it comes. But sexual abuse in this situation, while it may have been a motivation for Erik and Lyle to do what they did, does not constitute self-defense. And that's why Leslie Abrahamson said back in 1993 that sexual abuse does not justify killing your parents, and that they would never argue that. So what happens in this continuum is we analyze some of the examples of the lies and the differing stories that have been told, is that we actually saw stuff that was lied about before the killings, at the time of the killings, and in the months and years afterwards. And this evidence ranges from everything, including days before the killings, the Menendezes didn't go ahead and get their shotguns in Los Angeles and use their real names. They drove down to San Diego and used a fake ID and a fake address of one of Lyle's friends. Hours before the murders happened, they came up with a pre-planned alibi where they had actually gone ahead and contacted one of their friends to say that they were going to go to Batman the movie that night, and they would meet the friend afterwards at the Taste of LA event. During the murders, the way that the murders actually happened was instructive to understand the deceit and the planning that went into it. There was over 12 shotgun blasts that occurred that night. One of the shotgun blasts was to Jose Menendez through the back of his head. After he was dead, there were shotgun blasts to each one of his knees. The shotgun blast to the mom initially didn't kill her. She actually ended up lying on the ground, groaning and bleeding in pain. And that's at the point where Lyle and Erik Menendez had run out of ammunition, reload, and Lyle puts the reloaded shotgun up to his mother's face and pulls the trigger, thus staging it at the time like a gangland hit, which then becomes their deceit and lie in the ensuing months that occurred. Then you had the deception that occurred where they hid the evidence of their crime. They had the wherewithal that night before they left the house to pick up each one of the shotgun shells that had been expended. They then had the shotgun shells with them. They had the bloody clothing and the shotguns. And they proceeded to go to Mulholland Drive to dump the shotguns and to a car wash's dumpster to drop off the shotgun shells and their bloody clothing. Then they decided to execute the pre-planned alibi. Again, the deliberate, premeditated state at this point where they went ahead and they actually went to the movie theater to get the tickets for Batman the movie. Turns out that they couldn't get the 8 o'clock tickets because it was already past 10 o'clock. Then they called their friend to meet him at the Taste of LA, but by the point they got there, he'd already moved on. Then they actually called a friend to meet him again in another restaurant, and they never show up. Eventually, that friend comes to the house later that night, only to see police tape around the house. Now, after they were arrested, the Menendezes also tried to suborn perjury in a number of different respects. They contacted one of Lyle's girlfriends, Tracy Baker, gave her an actual script, a script that was actually found by the police, where it said that they wanted her to testify that Lyle's mother, Kitty Menendez, had poisoned them, had poisoned the whole family. She actually did testify to this extent in the first trial, but didn't testify to this in the second trial. They also contacted one of Erik's friends, Brian Eslamania, and asked him to falsely testify that Erik and Lyle Menendez were so fearful of their parents the weeks before the murders that they tried to borrow a handgun from Eslamania. He wouldn't testify to this. They also, again, as I mentioned before, asked a different girlfriend of Lyle if she would testify that Jose Menendez had violently raped her, and she wouldn't do that either. Finally, when it dealt with the handguns themselves, the Menendezes both testified that they had gone to the Big Five Sporting Goods in Santa Monica to actually buy handguns before they switched to the shotguns. But it turns out the Big Five Sporting Goods in Santa Monica in 1989 didn't sell handguns. So we looked at, again, the credibility of the letters, and particularly this Andy Cano 1988 supposed letter, weighed it in the continuum of lies, and it calls into drastic question whether or not this is in fact a 1988 letter written by Erik Menendez to Andy Cano about this sexual abuse. But again, even if it is, it's not timely because it was not presented at the time of trial. They substantially delayed in bringing this motion from at least 2015 to 2023, And in certain respects, it's also not admissible, which is why we conclude in our informal response that the court should deny the current habeas petition by the Menendez brothers. And if the court decides not to deny it at this point, the next motion or move for the court is to order what's called an order to show cause. Then we will file this again, this response, in response to the order to show cause. The Menendezes can reply, and the court can rule at that point or have a hearing in the habeas matter. So this is what we have been up to with respect to the habeas petition. Again, as I mentioned before, the governor has the clemency petition on his desk, and he can do whatever he wants, whenever he wants, and we will be dealing in the next couple of weeks with the resentencing issue. Let me stop at this point and take questions. And at the end of this, I'll have Maria Ramirez address the Spanish-speaking audience on these issues.
Yeah, the family
right here.
has been pushing for this. What did you tell them when you told them that you weren't going to support it?
So what I said what I said to the family is that I would listen to them, and we did. We met with the family for hours, and I heard all the issues that they have. And all the concerns that they have, and all the experiences that they shared with me during those conversations. Much of that deals with rehabilitation. Rehabilitation is not an issue for the habeas motion. And I want to make that crystal clear, that all the talk about rehabilitation will be talk that will be focused on in the resentencing motion. But as I mentioned before, the habeas motion focuses on the evidence at trial and any new evidence that might materially affect the outcome of that trial. Yes.
It seems that your examination of the case file so far has been significant. You demonstrate clear mastery of what you've seen, but it also sounds like you're casting doubt on the brothers' assertion that they were serially sexually abused by their father.
Again, what we have done is we've gone through all the evidence at the trial, which is the evidence that we have to work with. We looked at any testimony that was given by Erik and Lyle Menendez in the first trial, or just Erik Menendez in the second trial. We looked at all testimony that was given in support of the defense in either trial. We looked at any additional statements that we were given of people who had any level of percipient knowledge of the sexual abuse. We certainly looked at any other circumstance that deals with this question. And in looking at that, again, as I point out, that was the fourth version of what was told by the Menendezes in real time back in the 1990s.
So having reviewed 50,000 pages of documents, etc., do you personally now believe that they were not sexually abused by at least Jose Menendez?
What I believe is that they testified to that sexual abuse. They absolutely testified to it in great detail. I also understand that when it came to any corroborating information about that sexual abuse, it was extremely lacking. In fact, there were other, and the fact that it was their fourth version. In other words, they didn't come out initially and say, we killed our parents because our father sexually abused us. They didn't go ahead and when they got arrested, tell anyone that. They were saying it was a mafia hit and somebody else did it. They then, once they were arrested, they didn't again come out initially and say, my father sexually abused me. In fact, just the opposite. They were trying to say Lyle's girlfriend was violently raped by the father. Then the next version wasn't that the father sexually abused both of them. The father sexually abused Erik, but the mother sexually abused Lyle. So then you finally, and then you had, as you're aware, the Dr. Oziel tapes, where they didn't believe those tapes would ever be made public. But in those tapes, where Erik had gone to Dr. Oziel because he was suicidal and he needed to tell someone that he had actually killed his parents. At no point in any of those conversations that occur in late 1989 does Erik say that he was sexually abused by his father and that was any reason or played any role in what happened. Lyle, who's also interviewed by Dr. Oziel on tape, doesn't discuss that as well. And with respect to the mother, here's what they told Dr. Oziel. They said that they had killed the mother because they didn't want her to be a witness to the crime. That was reason one. The second reason they killed the mother is they thought that she was leading such a miserable life because the dad was cheating on her, that they basically thought that they were doing her a favor, which was the third reason, which is effectively a mercy killing, whereas Dr. Oziel testified euthanasia as to why they were killing the mother. At no point do they tell Dr. Oziel the father was sexually abusing them and the mother condoned it.
So just to be crystal clear, you're saying that the evidence does not exist that they were sexually abused by either parent?
What I'm saying is that the evidence, to the extent that evidence can include their own testimony, certainly that evidence exists. Erik Menendez testified for 7 days in the second trial in graphic detail, incident by incident, describing the sexual abuse he experienced by his father. Andy Kano talked about a conversation he had when he was 10, not when he was 16, but when he was 10, and Erik was 12 or 13, where Erik was describing that sexual abuse. So if you're asking me, was there evidence presented in the trial about it, there certainly was. If you're also asking me, has new additional evidence come out about that beyond the Andy Kano letter? There is none, or at least it certainly hasn't been discovered by the prosecution and hasn't been presented by the defense. Yes.
Have you tried to authenticate that letter?
We've asked for an original copy. The only way to truly authenticate that letter, there's only 3 ways you can do it. One, you need the original copy, or you need an envelope with a postmark. We've not been presented with the original. We've not been presented with an envelope with a postmark. The second is Erik Menendez. He himself, in a declaration under penalty of perjury, has said that he wrote that letter in December of 1988. And the only third person who could probably authenticate that, who passed away in 2003.
District Attorney, do you believe that the Menendez brothers should be freed?
The question about whether or not the Menendez brothers should be free will ultimately be a court question. Our job is to give the court the information and make the arguments, and particularly, and again, when it comes to the habeas motion, let me just start with the habeas motion, because that's what's teed up here. The Menendezes are asking for a new trial. In a habeas motion, I want to make this clear, you would not get off. You would not get released if you win the habeas motion. You would get a new trial, which is why I've gone through the trial evidence to show you where the new evidence overlaps with what all the voluminous trial evidence already exists. So at the end of the day, with respect to the habeas, you would not get freed in any event, even if you won. And as I said, with respect to this habeas, we believe it should be denied.
Have you just laid out a case, though, that Governor Newsom at least should think twice before he would even consider granting clemency?
I hope what Governor Newsom will do is what we have done. Certainly, we will, if he doesn't already have the 50,000 plus pages of trial transcripts, we'll make that available to him. I hope he speaks to prosecutors, defense attorneys, the Menendez family members. I hope he reviews all the rehabilitation records. Those also are voluminous, but they play in the resentencing motion. The clemency power he has is vast. It's unilateral. He can do it literally today. He could do it tomorrow if he chooses. He could also do nothing. Now, one example, well, that is the power that he has with respect to it. And as I pointed out as well, this is an interesting aspect of the governor's power. When it comes to resentencing, let's focus on that for a moment. What you'll have is that there'll be a resentencing hearing at some point. The judge makes the final call there. The judge can keep the sentence as life without the possibility of parole, or he can change the sentence to life with the possibility of parole. Let me play that out for you for one moment. If the judge, not the prosecutor, not myself, but the judge makes that decision at the hearing, then what will happen is it'll go to the parole board. That's the next stop in the chain of events. The parole board will then have a parole hearing at which Erik and Lyle Menendez will present the reasons why they should get parole. The parole board itself can make one of two choices. It can recommend the granting of parole, or it can recommend denying parole. And then guess who gets the case at that point? The governor. The governor then has 120 days to do one of 3 things. He can affirm that grant of parole, and they would be released. He can he can modify, or he can actually reverse the grant of parole and then they will not be released. And there's no appeal at that point. Now, as an example of where the governor has exercised the power to reverse the parole board, I point you to the case of Sirhan Sirhan. Sirhan Sirhan was the assassin of Senator Robert F. Kennedy back in 1968 in Los Angeles. He was originally given the death penalty, but the Supreme Court overturned the death penalty, so he got a life with the possibility of parole sentence. For 40 years and 15 parole hearings, Sirhan Sirhan had his parole turned down by the parole board. But on the 16th hearing, the parole board for the first time went ahead and granted parole. Then it went to Governor Newsom's desk. He looked at the fact that Sirhan Sirhan had been in jail, in prison, for over 50 years. He was in his late 70s. He was in diminishing health. But Sirhan Sirhan had never fully accepted responsibility for the actions that he engaged in. So the governor determined him to be a danger, notwithstanding all other factors, and actually reversed the parole grant for Sirhan Sirhan, who remains in bars today. Yes, right here.
It would seem, just sort of big picture, hearing everything you're laying out right now, it would seem like you are leaning towards not recommending they should be resentenced. Is that fair to say?
So with respect to resentencing, we have not finalized where we're going to end up, because it's not just the trial analysis. It requires an additional substantial analysis on the rehabilitation factors and other factors that are very unique to the resentencing statute. We estimate within the next 2.5 weeks, we'll be filing something at that point, and then we'll make our position very clear. Let me take one in the back. Hold on one sec. Let me take one in the back.
You're essentially saying that the Cano letter is not admissible, and the Rosello declaration is not admissible under the Habeas structure. Is that right?
So the Cano letter actually would not be timely, because we believe, for as far as Erik Menendez is concerned, it's a letter that wouldn't be discovered after trial, since he wrote it in December of 1988, and the trials were in 93, 95, and 96. As for Lyle Menendez, it would not be admissible, because again, it's an out-of-court statement, not dealing with Lyle's situation, but dealing with Erik's situation. For the Roy Rosello declaration, we're saying that is inadmissible, because a declaration about incidents that occurred between Roy Rosello and Jose Menendez in the 1980s that the Menendez brothers didn't know about to the 2020s, we don't believe could influence their state of mind when they actually killed their parents. So it couldn't play a role in self-defense or premeditated murder. Yes.
When it comes to the factors and the assessments that you've outlined as it relates to the habeas petition, can you elaborate on whether any of those factors and assessments will play into your review of the case when it comes to resentencing and other factors that you could consider?
So yes, we'll certainly look at many of the much of the evidence that we've discussed today as it pertains to the trial. But the resentencing motion goes beyond that. It really focuses as well on rehabilitation. It focuses on other factors that are identified in the resentencing statute. And that requires this additional analysis, which we are in the process of engaging in, and then we will finalize our position within the next 2 to 2.5 weeks. Yes, right next to you. Hold on one sec.
Governor Gavin Newsom has previously said he is waiting for you to review the case before taking a position on potential clemency. So what would you tell him outside of the fact that you want to give him your thoughts and opinions?
So I tell him to review, I think it's 88 pages, the 88 pages that we have filed today as a starting point, as well as the voluminous exhibits we include with it, including a lot of the trial transcripts, so that he can review for himself what went on at the trial. We will also, when it comes time for resentencing, deal with the rehabilitation aspect. We'll provide Governor Newsom with all that information as well to review. He can find some other source that he wants to review, talk to anyone he wants to talk to add to his database of how he wants to make his decision. But ultimately, the governor, again, he has absolutely unilateral, full power, constitutional power to commute that sentence. He can, and again, he might have the issue coming up on a parole issue if it comes through that path, but the clemency power exists separate and apart from habeas and resentencing. A question over here.
So when it comes to rehabilitation and resentencing, Lyle and Erik just did a podcast. They came on, and it's two angry men. I don't know if you had a chance to hear it, but essentially they talk about their whole rehabilitation process that they've been through, all the work that they've done with people, all the brutalization that they face behind bars. And I wonder what your thoughts are about that, because I know you've been looking into it.
So part of a good amount of the rehabilitation evidence was in the original resentencing motion filed by the prior district attorney. And it goes on for tens of pages detailing the rehabilitation that both Erik and Lyle Menendez have done over the last 30 plus years while in prison. To the extent, I don't know if they said anything, I have not viewed this podcast beyond what's already in the prison records that are very detailed about what went on in the prison. But again, to the extent that they want to supplement any information that the court's going to have, I'm sure through their counsel they'll do that.
And do you believe that they've been rehabilitated based on all you do?
Again, in our resentencing position, we will deal with the full scope of our thoughts dealing with rehabilitation in the context of resentencing, because that's what's important. The resentencing statute focuses certainly on rehabilitation, but other factors, and we'll make our position known like we've done it here today in the habeas position when we file our papers. Let me take another question back there.
There are many Menendez supporters all over the world who believe that they were sexually molested, and they say they've served more than 30 years. Isn't that enough? They'll obviously be very disappointed.
So what I would say again is that there are three different paths that the Menendez case is on right now. This particular path of habeas is a very specific path with very rigorous standards on how you get a new trial. Again, even if they won the habeas motion, they would not get out. They would just get a new trial. And we've gone through it fairly methodically in this press conference, and even more methodically in the informal response we submitted today to explain why we do not believe under these rigorous standards they qualify to get a new trial. Again, much of what they are arguing in this second habeas petition has been already brought to a trial judge who's rejected it. The direct appeal, which is the California Court of Appeal and the California Supreme Court, which has rejected it, back to the California Supreme Court with the first habeas petition, then over to the U.S. District Court and the Ninth Circuit Court of Appeals, rejected. So most of the arguments they brought in, other than those two new pieces of evidence, have been rejected by every single court that has heard them. So again, with respect to the habeas petition, I don't know if people understood what was involved with the habeas petition and how very specific and narrow it is, but that's why I've done my best, both in this press conference and in the video that we've put out, to explain how these processes work. Yes, over here.
All right, you have been listening live there in downtown Los Angeles. That is District Attorney.
You're mute, Joel.
I knew that would happen. That is courtesy of KABC News, which is Eyewitness News 7 in Los Angeles, California. That was really interesting, actually. Some people said it was putting them to sleep, but number one, I cannot believe the speed with which Nathan Hochman speaks. He gets a lot in there. You can tell he's, whether you like him or hate him, you can tell he's very intelligent, that's for sure. And he just basically, Joe Potuto, correct me if I'm wrong, but in a way, he just laid out almost like a closing argument. You could see his legal acumen in action there. And he basically came out and said that he put in a lot of hard work to understand the case, that they reviewed 50,000 pages of trial transcripts. They spoke with defense attorneys. They spoke with prosecutors from back in the day, and also every Menendez family member who wanted to speak to them. He kept calling, by the way, the original attorney is Leslie Abramson. He kept calling her Abrahamson because she spells it with an H, unless you change the pronunciation of her name. But Joe, you know, what strikes me about Nathan Hochman is he doesn't, you know, he is I guess, like what a journalist should be. He is totally, in my opinion, he is just laying out the facts and going according to the law. Like he's not taking a personal or like a vested interest in the case. Like it's hard for me to tell how he really feels, which I think is probably a good thing. But what did you make of this press conference just now? I mean, he laid the facts out well. Some people definitely don't agree. We can get into the psychology. Some people say he's not taking into account the fact what could happen as a result of being sexually abused, the type of behavior that would ensue, the hiding it, the covering up, all those sorts of things. But strictly from a press conference content standpoint, Joe Potuto, the floor is yours.
Yeah, and I have thoughts about everything, and
Yeah,
I found
good.
it very interesting too. And I've got a book on habeas, so I mean, I thought he was right on the law, straight across the line. He was right on the law. You can disagree with what the law should be, but he was absolutely correct on the law. He laid out the facts that he found in the record, and I thought he did it clearly. I would say, Joel, that he made it harder, I believe, for the governor to grant clemency in the way he laid this out. And I also think to some degree, he has signaled a little of what they might do with the recommendation on a resentencing. Because if you look at the resentencing, when he talks about rehabilitation, he also made it pretty clear that he thinks that the brothers have trumped up a letter that didn't exist and have produced maybe with regard to, was it Eric's letter to the cousin when the cousin was young? Maybe that letter didn't exist, and the Rosello letter he talks about, there's some question about it. If that's the position after he looks at the evidence for the resentencing that he continues to take, then the rehabilitation is a little called into question because you've got people not being honest with the court in these days. I thought the press conference was, for me, terrific and very detailed. I'm not sure for the working, media there, whether they felt they needed all that information to get their stories. And then they also couldn't stay on track because he made clear there were 3 tracks and he was just talking about habeas. Rehabilitation is irrelevant to that decision. And yet some of the questions went to rehabilitation. They also wanted him to take a personal stand on whether he believed the Menendez brothers warranted release, and he was careful to stay away from that too. And, I think that's what he should have done. I suspect he does have a position on it, but he's not disclosing it.
Yeah, not to mention the fact that they are also, in typical LA style, releasing a Steven Spielberg, no, I'm joking, not Steven Spielberg, but it is some sort of movie that they put together, documentary that's going to be available online. Again, there's a comment from Francis here. They didn't suddenly say they were abused. Eric first revealed it to Ann Burgess-True, who's been a guest on our show, and not until after several months. It came up very gradually. It took a long time for her to get it out of him, and Ann has been on our show talking about that. We'll get her back on. I think we'll do something on this probably next week.
But you've got to keep, you got to keep in a silo with regard to this. At the time, the evidence would not have been admissible in a self-defense claim. Evidence of, DA was also not admissible. Self-defense requires that you sincerely and reasonably believe that you are an imminent, not eminent, as he said. I think he was just mispronouncing the and I'm sure he knows the difference between the two words. Imminent danger of serious bodily harm or death. You cannot, on these facts, make the claim that objectively on the facts, they were in imminent risk. I think the parents were on the sofa eating ice cream and watching a movie at the time.
I guess, though, Joe, unless you buy their story that they felt that the father or the mother were going to both kill them that
Well,
night.
but it's still not imminent, because imminent requires that you have no choice but to act. What's
Okay.
happened since that time is there's been a relaxing for DA cases in which, if there's been a sequence of abuse, that the ability of the individual to reasonably assess how imminent the harm is, or to be able to reasonably assess that there are other options besides killing, allows that defense to be made to say, in this case, I might not think it was imminent, but that person did, and here's why. But that defense doesn't eliminate, it's not a defense in the sense that you walk free. It reduces the level of culpability, so the charge is no longer murder, it would be manslaughter. That evidence, that ability to even make that claim was not available then. So if you think about it now, and I was sitting here thinking about all the cases in which people look about murders now and say, we want them in prison forever. You know, you have in the Adelson case, the brother-in-law has the brother-in-law killed, right? Mm-hmm. Most viewers say life without the possibility of parole is the right answer. I can go through them. So take that mindset and bring it back to when these two brothers killed their parents. Assume that there was abuse at the time, and they acted on the evidence that the jury would have had. I don't think it's anywhere near a lock that the jury would have said, we believe the abuse, and not only that, we believe that it led them not to be able to accurately assess what was going on and to think they had to act immediately. You heard what the prosecutor said. You know, they had 4 or 5 different stories. They went out on a spending spree afterwards. They did all kinds of things calculated to disguise the fact that they were the actors. All that evidence would go before a jury. And that jury, even in the face of a full rendition of what the brother said the abuse was, I think could reasonably and readily still have could convicted of first-degree murder. Now, that's not to say what we should be doing now, but it is to say that I think we all have to keep in mind, one, what we think about this sort of conduct when we're looking at it at the first instance, and two, not simply the evidence of the abuse. One, you have to say the jury is going to believe it in the face of the full a range of evidence that's going to be before the jury when the jury decides.
Yeah. I mean, these are all excellent points. Misdemeanor, if you're joining us for the first time on this breaking news story with LADA Nathan Hochman, we bring you the best guests in true crime to break down the biggest cases. This is Joe Potuto, Professor Emerita, University of Nebraska Law. So let me just continue to kind of break down the press conference, and then we'll take questions as well if you have them. We'll go for a little bit here. But basically, Hochman came out, the prosecutor, the DA in LA, and he said there's 3 different tracks right now. You've got the Habius, which Joe Potuto has literally written a book on, and he looked at the new evidence, and that's why the photocopied letter, the so-called Andy Cano letter, is a cousin, the Menendez brothers, who died in 2003, I believe, from a drug overdose. That there was no date, there was no no envelope, so there was no way to authenticate the date. And he implied that would have come up much earlier on in this whole story / saga had I guess the intimation, he was intimating that maybe it was created after the fact. I don't know, but he seemed to not completely believe that it was a credible piece of evidence.
You have to say, Joel, that he's right. If you know the letter exists and you don't raise it the number of times you're trying to get out, that does raise the question about the the authenticity and the fact of when that letter was written. You can't quarrel with that. You can disagree with how you're going to read that and how much weight you're going to give it, but it certainly leads to that conclusion.
Yeah. By the way, this is totally, like I'd say 50-50 in the chat. This is a la Karen Reed. Half the people believe these guys are innocent, not of the crime, but deserve to be let out because of what they endured. The other people say no way. Ned Smith being one of them, who 1,000 times has already said to throw away the key. A lot of people do feel that way. But what's interesting
But let
again,
me say with regard, Joe, if I can say something with regard to that, even with, and I should have said it a moment ago, even with regard to the evidence, if you accept it, that Jose sexually abused both of the sons, and today they would have been able to raise what's called an imperfect self-defense, bring the evidence of abuse in and say that's why we reasonably believe we were in fear of imminent death. You cannot say that about Kitty. You cannot say with regard to Kitty that there's evidence of serious abuse. You would not be able to raise that defense with regard to Kitty. So if you're sitting on the jury, what the jury would be told, assuming that the evidence went in and they're entitled to get that jury instruction, was they were in imminent fear. They thought they were in imminent fear because of the abuse, and therefore they acted in the way they did. And if you believe that, you should, whether it's reduce it to manslaughter or whatever. It's much harder to say, and then they're entitled to think they were reasonably in fear that she was going to kill them too. Much harder to do. That's why I say this notion that the jury would have raced to a conclusion. I don't want to be unfair, but would have come to that conclusion had they heard this evidence, I think is, as I said, not a lock, particularly with regard to Kitty. I mean, how do you explain Kitty? If you're being abused by one person and you reasonably think you're going to be killed, you're entitled to kill the spouse too? That's a hard, it seems to me that's a hard leap to make.
Yeah, by the way, Nathan Hochman also lays out the 5 different stories that the brothers gave. And I think the 4th or 5th one is that the mother was, I think it was the 4th one, that the father was molesting Erik, but the mother was molesting Lyle. So they do sort of cover all their bases. The point I just wanted to make real quick is that we do have a lot of people who watch STS who are victims themselves, which we like to call survivors. And I think it's important. This DA is not looking at this, and maybe he should be, but he's not looking at it through the lens of someone who was abused and how they might respond. I don't think he's taking any of that really into consideration. He is literally just looking at the facts here. And there's a question about disregarding the jury. Back in the second trial, they were really suppressed in what they could even bring in related to sexual abuse, Professor Potuto. So in a case like this, where there is a strong possibility that these boys were, and look, I've told the story a gazillion times. I used to play tennis with these guys, so I have some personal, I was never in their house, but I have a lot of friends that were there, and I've heard stories that at least the father was not the greatest human being on earth. Let's put it that way. I famously told a story. Well, there's a famous story that I've told about they had a white carpet in their Princeton home, and at a party, some friends spilled red wine on it, and the reaction from the brothers didn't measure up. They were like fearful for their lives. It wasn't like, oh, dad's going to kill me. It was like they were actually fearful for their lives. So I don't necessarily doubt the story here of abuse. As a matter of fact, I think it's probably very likely. But how does that, again, Joe, the law doesn't have feelings is the point I'm making.
Yeah, and if you think of you've covered some DA cases, in the last couple of years. It comes in with regard to if the person is suffering from I don't know whether they call it a syndrome or whatever they call it, so that individual is unable anymore to assess that she can or he can get out of the situation or how imminent the harm is. that the jury is entitled to consider that in terms of deciding how reasonable the action was. But it doesn't get you an acquittal. It gets you it's no longer murder, brings you to manslaughter, which obviously would have a, lesser sentence attached to it. And I have no doubt, I saw a couple of the comments that came up, that someone who's an abuse victim may find it difficult to talk about it and may not talk about it and be reluctant to talk about it and not even tell a psychologist, or be reluctant even in the context of a criminal trial to raise it as a defense. Those things would go to a jury to assess whether they believe that in this case, the brothers are credible when they said there was abuse, given the evidence that they didn't report it, quickly or whatever. The jury would have all that in order to make the decision that there was or there wasn't abuse. But as I say, the problem, I think, you give all that with regard to to Jose, you still have the problem with Kitty. I mean, if you think about it as a modern trial, if you had a person today who was suffering from DA in a family situation, what would we say about an active trial where the victim not only kills the abuser, but somebody who was living in the home? It's tougher. So all I'm saying is I think the conclusion that there was abuse and the conclusion that today the abuse would be relevant in some ways in the criminal trial doesn't automatically lead to a conclusion that they would have either been acquitted. I don't even think that would happen, but that there would be a lesser decision. So what happens in the Habeas case, and the reason why, if you think about this, when the prosecutor went through the number of times the thing was raised, you have to have finality in the system. You can't keep re-raising the same issue over and over and getting the same result. So each time you raise it again, the standard by which a fact finder or a judge is going to decide in your favor reduces, because the bar you have to jump is higher. We don't say that the first time somebody concludes you did something on a very high standard, that should be the same standard the sixth time you have somebody look at it. And so that's what's happening. And for Habeas, what the rule is you have to have new evidence. You can't just keep raising the old evidence, because the system can't be burdened by people constantly being able to bring, hoping sooner or later they're going to get a different result.
Yeah. By the way, I'm going to try to get Ann, Dr. Burgess, back on, a literal living legend. And she did work with Erik during the first trial, not on the second trial. And by the way, I don't think it's mutually exclusive. So they could have been greedy, and they are killers by everyone's account, but they also, buying the Rolex watches, but they also could have been essayed by their father, even possibly their mother. It's not like one or the other, but you have a lot of people in here who are saying, well, I was essayed and I didn't, kill anyone. And 99.9999999% of those who are victimized do not kill. So then again, it goes back to the letter of the law. But I just want to get through a couple other things here. So again, the three tracks, the first one we went through very, thoroughly is the Habeas track. The second track is petition for clemency from the governor. And a lot of people are saying there's no way that's happening, because Newsom's going to want to run for president in 2028, and he's going to lose the vote, the popular vote in America, they believe, if he was to grant them clemency. And then the third one is resentencing. And if you remember, there is still on the docket a court date, March 20th and 21st, where they are going to take up the resentencing issue. The DA, Nathan Hochman, said he's going to have a take on that, or an answer to that, in 2 weeks, which is just shy of when this hearing will be. But look at that, an old school phone. But the way I look at it, Joe, is he was fairly transparent today. I cannot see him coming back and in any way saying, yeah, I recommend resentencing. I think he's going to come back and say he's against it. So then what?
Yeah, I do too, in part because he made a pretty strong case even before he got the questions about whether the new evidence is really credible and reliable and the extent to which the brothers may have created the evidence, or at least exaggerated the evidence, and that would go to the rehabilitation standard. So I think, given what he said today, since they haven't looked at everything, that I think he'll give it a fair read and go through all the evidence that would be relevant to resentencing that's not relevant in the habeas case.
So just to continue on, by the way, if you guys want to watch the movie produced and directed by Spielberg and George Clooney, it's at da.lacounty.gov, da.lacounty.gov. He went on, Nathan Hochman, to say that sexual abuse does not justify murder. That is, this is like kind of the point of contention amongst everyone, those who believe they should be freed and those who think that they should not be freed. Again, he talked about the Andy Cano letter, which is a letter to the cousin, basically admitting or stating that he was abused, that Erik was abused by his father. If the letter is real, Nathan Hochman said, well, why was this delayed till 2015 during a Barbara Walters interview? And then it took more years to get it in front of other people. And then the other piece of evidence that he looked at is Roy Rossello, better known as a member of Menudo, the boy band, who then did a documentary a year or 2 years ago stating that Jose Menendez had, essayed him. But then you get right back to what Joe was saying. Is there imminent fear? Was there imminent harm? Is the evidence credible? Is it not credible? And then, Joe, and then I'll let you hop back in, Nathan Hochman lays out 5 different versions of what happened. And I've literally been following this since 1989. I didn't remember one of these. But the first story, they said it was a mob hit. They weren't home. Not true. Second one was Jose was a violent sexual predator who had Ard, the word, Lyle's girlfriend. Now, I don't remember that. That's weird. So that I was kind of surprised by that. But that was the second story. Number 3, the father molested Erik, and Lyle was molested by the mother. So that's where the mother comes in. Story number 4, Erik and Lyle both molested by Jose. And number 5, that imminent danger, the parents were going to kill them that night. I mean, Joe, again, if this was an issue of a new trial and you present these 5 different stories, unless you have Dr. Ann Burgess, someone of her stature, getting up there to say memories can be, completely thrown off by SA. I mean, barring that, 5 different stories about what happened, it's not going to look too good to a jury, even in 2025. Right?
No, it's obviously it's going to affect their credibility. Now, that doesn't mean a jury can't discount it and say they were making up the stories because they didn't want to get arrested. It doesn't mean it didn't happen. It does mean you said you can have two different things going at the same time. I mean, I can have a good reason why I do something, but it's still a crime, and I would still rather not have to go forward with a trial explaining it. I'd rather just not get caught and get arrested. So those two things are not, I think, mutually exclusive. But a jury's would have to decide, how much to weigh one against the other. And I do think, Joe, I'm trying to remember, it may be that you didn't hear all those stories because they weren't all part of the public record. I mean, you heard him say that the claim that Kitty had abused one of the brothers was not even raised at trial. When they got to trial, it was not even, used. So it might have been in the trial. I don't remember now whether they tried to impeach one of the brothers saying you said this too, or they didn't impeach. And if they didn't do that, it might well not be part of the public record, or at least the big enough part that anybody would remember.
Phantom 6000, friend of mine, friend of the show, looks on. He's looking Unabomber-esque there, but he's not. He's a lawyer, very smart. He says, and he knows Nathan Hochman personally. I hope I didn't say too much. They shotgun mom went outside, reloaded, and shotgunned her again. Nathan has done a very reasonable analysis. 100% agree with that. I mean, he laid it out. Let Newsom make the political call. Agree with that too. Cousin was on a stand. Best evidence comparable to the letter, I think is what he's getting at there. All, interesting. These are all like really viable, good points. Yesterday, this is when LA makes me snicker a little bit. So these guys did a podcast. Lyle and Erik don't talk publicly very much, but they did a podcast yesterday for TMZ, which is hosted, I think it's called Two Angry Men. Yeah, it's Two Angry Men, and it's hosted by Harvey Levin, who founded TMZ. And then the other, I don't know if Mark Aragos is the other host, but he hosted yesterday, and he is now representing the brothers Menendez. And basically, it was almost to me like a PR move, like an LA type PR move. Erik Menendez talks about his experiences in prison facing violence and bullying. He says it was very traumatic, which, look, you're going to go to prison. It's going to be violent and you're going to be bullied. I don't know what kind of public, sympathy they're expecting to get there. Again, he said, I faced a lot of bullying and trauma. It was a dangerous environment. I was picked on, bullied violently, and it was traumatic and it was continual. There's things a lot of inmates in prison go through when they're not part of a gang structure. He says, I'm not going to fight back. I'm not going to, engage others. And I had no one really to turn to. He talks about a time that Lyle had his jaw broken and talks about how if they were together, they'd be able to help each other. But Joe, the bigger point here is the timing of this is interesting, that they spoke to this podcast yesterday. I don't know that they knew DA Hochman was going to come out today, but they obviously know that there's this hearing coming up. Is this a PR attempt? And if it is, why are they talking about the fact that jail is violent? Everyone knows that. I mean, anyone who's anybody knows that.
I think that I don't know that I necessarily, I don't want to make PR sound pejorative. They have a right, if they can, to make their position clear and to try to generate some public sentiment in their favor. I don't quarrel with that. And I think part of what the prosecutor did today, both in doing that very detailed recitation, but also with the video they're doing, is to counter that and give the other side. In our world today, people make those claims in the public and hope to generate public opinion and therefore movement one or the other. And I don't quarrel with it. Part of what troubles me about this case is if we think sentences are too long, and they're the longest in the world, we think they're too long, that's an issue that we should be addressing through the legislature and changing them for everybody. Not having long sentences that we embrace, and then in a particular case that may not be substantially different from other cases, make a different result. We think prison is a horror show, and we do, then we should be doing things to reform prison and not the one person or the couple of individuals who can make that case for themselves get the benefit. I'm really troubled by having, general rules that we say we want as a public generally. Sorry, this thing is just buzzing at me.
I love it.
Yeah, well, it's so I don't even know what.
If anyone was falling asleep, they're up right now. By the way.
Well, and I don't know what I thought I needed to be reminded of at 5:17 Eastern time. So I don't even know why it's going up. But if we make the decisions we make as a body politic may be right or they may be wrong. But those are and if we don't like them, change them. But doing it in particular cases that may not be different than other cases really troubles me, in particular because the people who are likely to be able to do it in some way or other, whether it's money or the kind of job they have access to making those claims that others don't have. And it seems to me that's not right, that we want this standard, except, if you've got access to the media or you got special access, you can get it changed for you.
Yeah. Misdemeanor saying Joe is even-handed and law-based. That's how I think DA Hochman presented things today. Again, a good journalist, you shouldn't know their political leanings, and it was hard to tell. I mean, seems like he doesn't think they should get out, but personally, you can't tell, and I think that's a good thing. Vesper Martini, if they're set free, will you ask them to come on? Even if they're not, I will. I've been meaning to. I would love to. I know a lot of people in common. I mean, we had the same tennis coach. That's for starters. I bet you these guys could pick up a tennis racket, by the way, today, 35 years later, and kick most people's you-know-what. These guys were almost at a professional level playing tennis, but they obviously don't have access, I don't think, to too many tennis courts over the last 35 years. But I bet you Phantom 6000, by the way, is an awesome tennis player from what I understand, but I bet these guys would be pretty damn good, but that's neither here nor there. So Joe Potuto, the next hearing, as we were talking about, is March 20th and March 21st, where a judge now is going to decide about this resentencing. So Hochman, the DA, says he's going to have his position on this in 2 weeks. What can we expect? I know you're not a trial lawyer, but you know more than most. What should we expect during this 2-day hearing, March 20th and 21st?
I think it's an evidentiary hearing, as I recall.
Joe, real quick, Space Coast is asking if they would beat me today, 6-love, 6-love, 6-love in about 3 seconds. Go ahead, Joe.
Well, I couldn't figure out where the ball was bouncing when I tried tennis, so I'm not even in this conversation. As far as I was concerned, when it bounced, it could get in any direction, Yeah. I couldn't predict it all. I tell you, I don't know what's going on. I have to. I'm letting it go because I'd have to.
Is that an alarm? What is that? Is that like
it's an alarm on the Apple phone?
Oh, okay. Well,
and I put it on when I need to do something that reminds me to do, but there's nothing right now. I have something at 6, but it's not anywhere near 6. I thought it was, I'm not sure whether it's an evidentiary hearing or not. It could be a hearing. If it's a hearing on the motion and there's argument, then they'll have submitted their papers and they'll make arguments in favor or against. If it's an evidentiary hearing, then they're able to actually bring witnesses in who can testify. I don't think it's the latter because I can't imagine why they would need to have actual live witnesses, but I don't know for sure what they do in California when they're doing a resentencing. And you heard the prosecutor say this is kind of unusual to California to permit it.
By the way, the COE does call me Joelle, and she spells it that way. Carm breaks my name into 2 syllables. Syllables. Yes, that is the word. A final thing here, Joe Potuto, to you. Anna Maria Baralt, she is Jose Menendez's niece. Now, even Kitty Menendez's sister, her own sister, says these guys should be freed. And there's a whole thing called the Justice for Erik and Lyle Coalition that the family is spearheading with other people's help. But she said it should just be reduced to a manslaughter charge, I believe, with time served. The quote is, "We are very much hoping that we can find a path to manslaughter. To understand that going to a parole board for our family will only serve to re-traumatize us more." Kitty's 90-year-old brother, he remains adamantly opposed to their release, but I think 24 members of the family, including Kitty's sister, came forward saying it's time for them to get let out. I mean, but again, Joe, most family members of most people who are incarcerated want their family members out. This happens to be a very affluent, high-profile name that everyone has, heard about over the last 3, almost 4 decades. 4 decades, I think. What role should the family have in all this? And your final thoughts on this?
Yeah, that's kind of controversial. For many, many years, families of victims were not permitted at, let's say, a sentencing hearing to enter a position. And the reason was not all of us come from loving, supportive families. And it probably has a disparate impact on those who are disadvantaged. I don't want to say income level has anything to do with it, but there are people come from families that don't care about them. And that gives an advantage to families where they've got relatives who care, because they will come in and support. And so it's very controversial about whether to allow those sorts of statements at all. I think they should come in. But you can have 20 family members. I mean, in this case, I think most of them believe there was abuse, as I recall. But take it in a case where 20 family members believe there was no abuse, believe there was no abuse, but enough time is enough time. That gets you back again to, I mean, think of Susan Smith. What if she had family members who said, enough time is enough time? It's hard. I think it's relevant. And in this case, I think it's more relevant because it's a family member talking about the death of family members. So it's not me saying, you came and killed my mother, you should never get out. Or you came and killed my mother, but it's okay. This is one where they've got relationships both ways. So I think if I were looking at it, I'd probably give it a little more weight, because they're talking about the death of a brother or a brother-in-law and not simply supporting nephews that they want to be released. But I don't know how much weight you should be able to give it. I mean, the fact that there's nobody alive on the other side, or only one person alive on the other side, doesn't mean, that the murder didn't happen, or that there shouldn't be, strong consequences for it.
Really well said. Big thanks to Professor Emerita of both STS and the University of Nebraska Law School. She is our Professor Emerita as well. Joe Potuto, she is awesome, as you've all seen, and can break it down for law students like myself. This is obviously a very polarizing case. I don't even want to compare the two. They're not comparable, but Karen Reed, because that case is irritating the crap out of me. Interesting news there. By the way, if anyone, again, I always want to get the community's feedback. I said I am not covering Karen Reed part 2, but if you have an interesting way for me to cover it, and I don't know what that is, I have no idea, but if there is a interesting way to cover it, please email me, survivingthesurvivor@gmail.com. It looks like Alan Jackson's got a couple of problems on his hands, and now they're putting out shirtless pictures of Paul O'Keefe. So that's where we end today. That is to victimize a victim's family is, in my opinion, absolutely disgusting. And what's going on in that case is disgusting.
You can end with the third. Was that the third or the fourth?
Third time's a charm. So if anyone has anything to do, that's your reminder right there. And please, if you appreciate the content, you appreciate Joe, you appreciate the guests that we have, we cover the biggest criminal cases with the best guests in true crime. Please hit that like. Please hit the subscribe button. We'll be back next week with a full slate of shows. We will see you then. Love you, America. Love you, Jersey, where the Menendez brothers and Joe and I are from, the greatest state in the union. And then you've got Florida, where I am, California, LA, and you've got Lesotho, Africa, where we now have viewers, and not many people can say that. If you don't know where Lesotho, Africa is, look it up. We'll see you next week. Love you, everybody.